Cyrus Mehta is a widely acclaimed immigration attorney, very well respected and cited in several sources. Mr. Mehta, welcome. I have several questions for you regarding the proposed rule changes to the H-1B program. Could we start off with an overall, with an overview of the proposed rule?
I think when one reads the rule preliminarily, it looks good. It does try to promote efficiency, and it tries to keep up with the times. So there are some very good aspects to the rule that should be commended. On the other hand, it redefines the specialty occupation, and I think that's the main problem. That may result in requests for evidence, which will create burdens on employers, and it could also result in denials.
And does this largely eliminate folks with just a bachelor's degree?
If you have a bachelor's degree in a specialized field and the position requires it, no, you can still qualify for an H-1 visa. Just to give you an example, let's say you are being hired as a software engineer and you have a bachelor's degree in computer science. You should be able to qualify for the H-1 visa. The problem here is that the rule says that there must be a direct relationship between the duties of the position and the degree. So if you don't have the right degree, or the position doesn't require a specific degree, then there'll be a problem. They give the example of a generalized degree like business management, which is very troubling. If you have a degree in business management, and let's say you're hired as a marketing specialist, but your MBA degree is a general degree, but it's a great MBA degree from a great business school. The rule says that you can't qualify for an H-1B. You'll have to show that your degree has a specialization in marketing. There are many MBA degrees that don't specialize in a particular field. You get a general MBA degree. And this would apply to any of the professions. Like a law degree, you get a JD degree. If you are employed as a tax attorney, you don't have to demonstrate that you have a law degree in taxation. A law degree would qualify you for the H-1 because the legal profession always requires a law degree. Mm-hmm. So I don't see why they had to differentiate between the MBA degree and other degrees. So that could be a problem. And then they also, in the commentary to the rule, there is reference to a general engineering degree. So let's say the position requires an engineering degree and it's for a software developer. That could also create problems for the petitioner. One would have to demonstrate that the position requires an engineering degree in computer science or something related like electronics. But let's say the engineering degrees in the field of ceramics.
Yes.
But that's why they say that if the job just requires an engineering degree, that could also create problems and result in a denial. But I think the regulation goes narrower than the Immigration Act. The Immigration Act doesn't require that the degree must be specifically related, or there must be a direct relationship between the degree to the duties of the position.
Absolutely.
So, for example, if you're hired as a journalist and you have a degree in a non-journalism field like English or economics, so that might also, they might also use that as a basis to argue that there is no direct relationship between your job as a journalist, and your degree in economics. Now, if you're working for a financial magazine and you're doing financial journalism, or you're working for the Wall Street Journal or the Economist, then yeah, you would be able to show that. Now, that has always been the case in H-1B practice, but the fact that they're codifying it and giving ammunition to USCIS examiners to object to an H-1B in that manner is problematic, because the broad Immigration Act doesn't require a direct relationship to the duties and the specific degree.
Interesting. So do you expect to see a significant drop-off of applicants from India, given
No,
that...
I don't think so. No, I don't think so. I think one can still make a case for an H-1. If, let's say, you have a person who's got a degree in anthropology, but they have worked for many years in marketing, you could still then combine the experience in marketing with the anthropology degree and establish that the person has the equivalent of a degree in marketing based on a combination of the liberal arts degree in anthropology and the work experience that he or she obtained in marketing. So there are ways to still kind of establish the H-1B, but there was really no need to say that if you have a generalized degree in liberal arts or an MB, a business degree, and then as a sidebar saying that if the position requires an engineering degree in any field, then it would not qualify for the H-1B. This is old law, from 30 years ago. We know business degrees today, an MBA degree, it's a solid professional degree. It should equip you to be employed in finance and HR, in business technology.
Right.
So to kind of, latch on to that old notion that a business degree is generalized is problematic.
Absolutely. So what do you see as the aim here? Why did the Biden administration announce this proposed rule at this juncture? Is it attempting to curtail the overall scope of the H-1B program?
It's hard to say, because this portion of the rule is copied from the Trump rule that never went through.
Right. I was going to ask you about
that. But there
next.
are other features in this rule that are really good. Like you can, if you're an entrepreneur, you're the owner of your own company, you can also file an H-1, although they will now create some guardrails. Till now, if you're an owner, you can still establish an H-1B on your behalf. I think what's really good is that you don't have to show the employer-employee relationship under common law. That used to be a problem, especially if you had a business model where the employee worked at a third-party site. Again, taking the example of IT consulting, oftentimes the USCIS then said, establish that you can still control this person's employment. You have control over the person's employment. That has been eliminated. So there are good features in the rule, but there are some problematic aspects too. And again, this is like a proposed rule. There's a 60-day comment period. I'm hopeful that the Biden administration will listen. I think they have proposed a rule in the right spirit. They want to make it efficient and modern because of the good features. So hopefully they will listen, and they will broaden the definition of specialty occupation, which right now has been narrow.
Right. I wonder, to politicize this just a little bit, given our fraught relationship with China at the moment, where a significant number of H-1Bs also come from, do you see this as tying into that relationship, the attempt to sort of narrow and curtail some of the applicants, H-1B applicants?
I don't think it's so clear-cut. I don't think there's a direct relationship between China and H-1. I think it's basically organized labor doesn't like the H-1.
Right.
And you have economists on the left who feel that H-1Bs are being abused. And so labor has always been against H-1Bs historically. But that doesn't mean that policymakers on the right or politicians on the right love the H-1B program. They don't like it because they feel that there are too many foreigners coming in and taking American jobs, like the way Trump thought.
Right.
I just think that there's just this general suspicion about the H-1B program. It's historic. It's been with both parties, and they basically just feel that there have to be some restrictions. They shouldn't be made easy.
Absolutely. And Biden has established himself as a very pro-labor president. He was
Oh,
out on
yeah.
the picket line
Biden is,
with the UAW workers recently.
yes, Biden is cut from that cloth. So Biden would be sympathetic towards the sentiments of unions.
Mm-hmm. Absolutely. Countries such as Canada and Ireland are currently expanding their foreign workers programs. Will these countries eventually take over the US in terms of attracting talent from abroad, especially India?
They're trying to do that. They are trying to, but ultimately it also depends on the economy, which is the strongest economy, which has the most promising jobs, where do you have the best avenues to attain the very heights in your career. And if the United States still allows you to do that, and if you're lucky to get the H-1 and you get a good job, then people will still remain in the United States. There's always this attraction, even though the Canadian immigration program is more relaxed and it makes more sense. People use that temporarily, but ultimately they want to come back to the US if they get an opportunity.
Interesting. So the Trump rules eventually got thrown out by the courts. Do you expect the same thing to happen if this administration does manage to get this rule passed?
It's hard to say because I think I can see lawsuits on both sides.
Mm-hmm.
I can see lawsuits even by the folks who don't like F1 practical training. They lost, on the OPT. And what the rule is trying to do is to kind of extend the cap gap from September 30th or October 1st to next April. So it's kind of granting an automatic extension of that cap gap. So if you file an H-1 and you're in practical training, and even if it expires before October 1st, which is when the H-1B takes effect, your F1 practical training automatically extends to October 1. Mm-hmm. What this rule will do is to extend it even further to next April 1. So I can see people who don't like practical training saying, aha, this now is ultra vires the statute. There's no authority to do cap gap and to extend it. So I can see lawsuits coming on either side, attacking this rule.
Interesting.
I think before that happens, I'm hopeful that the administration, because they have promulgated a generally good rule that makes a lot of sense, they will at least try to soften or broaden the definition of specialty occupation. Like, I think if they remove the language that generalized business degree is not a basis for an H-1, that would go a long way. And the same with engineering, although they have not stated that in the black and white proposed rule. They've stated that in the commentary.
Interesting. So it goes through the 60-day comment period. And this is a basic question. What is the process after that? Must Congress approve the rule?
No, Congress doesn't get involved because this is a regulation. So then it has to be reviewed by the Office of Management and OMB, Management and Budget. Yeah, so then they look at it, they look at the cost factors, the feasibility, and once OMB approves it, it becomes either an interim rule or an interim or a final rule.
Mr. Mehta, I want to conclude with a question. Given that the process for getting an H-1B in the first place is become a little more complicated with this proposed rule, and given that you now have an 8-decade-long waiting time to convert that into a green card, is there any advantage for Indians to still come to the US on an H-1B?
That depends on the individual. They are saying it's 8 decades or even more.
Yes.
But, and it may well be, but we have seen people who filed in 2011, 2012 get their green cards today. Yes, the priority date has gone back, but people have been getting their green cards after a 10-year wait. It might be longer, but there is that hope that the law will change.
Right. To eliminate per country caps.
Yeah, like either the per country caps get lifted or more visas get infused into the system. It badly needs more visas, or there should be more carve-outs. Like STEM degree holders should not be counted.
Right.
But the 65,000, it was arbitrary when it was enacted in 1990. And it's never changed since then. That's for the H1, and for the green cards also, to have those per country limits and 140,000 overall, that can also change. Those visas can also be expanded.
Absolutely. Thank you. Is there anything you'd like to add before we finish?
I'd just like to add that, there are these good features that I spoke about. There's also, but one other negative feature is that they will again invoke the fact that you have to give evidence to show that the job is not speculative. So when you have a job that requires placement at a third party, in the past, they kind of, asked for meticulous contracts and work orders, which really troubled employers because sometimes it was hard to get those from the client, even though it was a bona fide job. That's going to come back with a vengeance. So, the contracts requirement to show that the job is not speculative. They also require you to show maintenance of status, which is not new. We've always had to show that, but there seems to be some creep here. Like, they may argue that if you were not paid properly, the employer abused the program, or violated their wage requirements and didn't pay the beneficiary, even though it's not the beneficiary's fault, that could be considered a maintenance of status, and then the extension may not be granted.
Interesting.
So there are troubling features in the rule. There are problematic things. In an otherwise rule that has good intentions, that does want to kind of modernize and reform the system, but then they have latched onto these old things. Even when somebody's working at a third-party site, and if they feel that the person is being staffed there as opposed to being assigned there as part of a consulting job, but it's it's being staffed in the client site, then they will want to get the views of the client. What kind of degree do you need? It's not really the employer's perspective anymore, but they will also want to know the client's perspective. And that's going to be very problematic to ask the client to say that we need a bachelor's degree, because the client is contracting with the petitioner. They're not the employer.
And I ask you again, you don't expect to see any significant drop-off of applicants from India if the proposed rule does come through?
No, I don't think so, because people will still try. And it used to be like this in the past, during until 2016, no, well, actually it was until about 2018 or 2019, we had all these restrictions. And then there were lawsuits that were filed to undo the burdensome speculative, the contracts requirement.
Mhm.
But so we are used to dealing with that, and we were still able to get approvals.
Absolutely. Well, do you expect to see a decrease in approvals?
It's really hard to say right now, because on the one hand, they won't be wedded to the occupational outlook handbook anymore. They were interpreting when the occupational outlook handbook for an occupation says that the job typically or mostly requires a bachelor's degree. They used to use that saying, well, it doesn't always require a bachelor's degree.
Right, right.
So like systems analyst, the way the job is described says it typically or mostly requires. Now the rule clarifies that and says that if the word typically is used, it means that it is a specialty occupation. It need not always say always.
Interesting, interesting.
So, there are the good features counter some of the negative aspects. So it's not overall bad. I wish it could have these negative features wouldn't have been there, but there is still scope for improvement. I would recommend that people send their comments.
Absolutely. And could you advise us on how to do that?
Well, when you go into the rule, there's a link, and you have to basically send your comments through that portal in the link.
All right. Sounds good. Well, thank you again for taking the time.